وعندنا المفلس الذي يحجر عليه القاضي هو من زاد دينه على ماله. فإذا كان الدين مساوي للمال الذي عنده أو الدين أقل من المال عنده فلا يحجر عليه القاضي.
So when the key word is above his assets, if the amount of debt he has is equal to his assets or below his the value of his.
نعم، هذا الدين لأجل يحجر عليه القاضي لها أوصاف، له أوصاف. نعم، ايش اوصافه عندنا هذا الدين؟ لابد هذا الدين يكون حال ليس مؤجل.
Must not be due.
لا يحجر عليه القاضي.
So if the debt is not due, meaning it's due only at a later date, the judge, he cannot put an interdict on him today.
الصوت بدأ يضعف. طيب.
الصوت واضح عندنا حسين.
عندنا يقول ماذا؟ كذلك عندنا هذا الدين لازم أن يكون لازم. كيف شيء عندنا لازم؟ يقول فلا حجر الدين غير لازم. عندنا يسمونه الدين مكاتب. إذا السيد كتب على العبد كتبتك على الذي مثلا ب100,000 درهم خلال شهرين مثلا، نقول هذا كتب عليه الدين، لكن هذا الدين ليس لازم، ممكن يكون خلاص سأرجع إلى لما عبد عندك، فهذا الدين ليس لازم فلا يجب عليه القضاء.
One of the second condition of what type of debt it must be is what is known in Arabic as lazim, meaning it is a firm debt which doesn't have the potential to be rescinded at any point. The example Said gives is, I'll translate it as a firm debt, meaning it can't be rescinded, is refers to what is known as a debt of the mukatab. A slave who wants to purchase his freedom, the debt that he owes the owner, so he purchases his freedom. Debt, meaning at any point in time during the 3 years he has to pay the master off. He can say, I don't want to pay it off anymore, then the debt falls away completely. He doesn't owe the master anything anymore. So that debt there has the potential to fall away. That's what is known as a non-firm debt, or a ghayr lazim in Arabic. So we're referring here, a debt that we're referring to here must be a debt that has already set and cannot fall away.
ليس دين لله سبحانه وتعالى، من كان عليه كفارة الزكاة ما يحج عليه القضاء، يأخذ الكفارة يأخذ الزكاة، لكن لا يحج ماله على دين لله سبحانه وتعالى، يحج عليه إذا كان هذا الدين أدنى.
The third quality that the debt must have for the judge to be able to place an interdict is that debt must be due to a human being. It must not be due to Allah subhanahu wa ta'ala. For example, a debt such as a zakah that is due to Allah subhanahu wa ta'ala, or a debt that is due as an expiation for something, these are debts due to Allah. They are not due to a specific individual owed to because of a transaction. Only if the debt is due to an individual or human being, then a judge may place a interdict on that person. Those are the quality of the debt.
نعم. طيب عندنا يقول ماذا؟ طب متى يحجر عليه القاضي؟ يحجر القاضي على المفلس هذا إذا كان بطلب منه، هو طلب، قال يا قاضي احجر علي، أنا علي ديون ودائما أخذ الفلوس وأصرفها، فاحجر علي حتى لا أصرف إلا في قضاء الدين، فالقاضي يحجر عليه. كذلك عندنا ماذا؟ إما بطلب منه أو بطلب من غرماء.
So at what point does the judge place an interdict? So it's in two places, in two scenarios. One, the person who is insolvent, he himself requests that the judge places an interdict on him so that he can't transact. one. Or two, the debtors themselves come to the judge and say, please place an interdict on this person to prevent him from transacting further because he has debts that are due to us, that are overdue, etc. Right? So those are the two scenarios, either himself or the debtors.
كيف صورة الحجر هذا؟ ما هي مثاله؟ ما هي صورة الحجر؟ كيف مثاله؟
Yeah, what is the we're going to give an example of what is of insolvent person being an interdict being placed upon them.
مثلا عندنا يكون مثلا أن يكون لزيد مثلا على عمر نقول 1000 مثلا دينار.
So a person Zaid has a debt upon Amr of 1,000 rand or 1,000 dinar.
مثلا وهذا الدين حال لازم.
So the debt that this person has upon the other one, that Zaid has upon Amr, it is a debt which 1,000 dinar, which is hal, which is due, lazim, which is a firm debt, which is not going to fall away.
وهذا الدين زايد ال1000 دينار مثلا زايد على المال الذي عنده.
This debt that is due upon him is above his assets. So the 1,000 dinar is more than what his assets are worth.
فزيد هذا الذي له الدين يقول القاضي يا قاضي احجر على عمر.
Amr who has
عليه ديون كثيرة.
So Amr who has the 1,000 dinar debt due and it's above his current asset value, Zaid who's owed the debt, he can go to the judge and he can ask the judge, oh judge, please place an interdict against Amr who owes me this debt because his debts are above his assets.
يقول الحاكم منعت عمرا من التصرف في أعيان ماله.
So then the judge then makes a statement and gives the judgment. I make a judgment and prevent Amr from transacting in his physical assets.
بعد ذلك عمر كل أعيان ماله بيته سيارته أي أثاث في البيت مثلا جواله ما يمكن أن يبيع شيئا منها. So
once the judge places the interdict against Amr, who owes the debt, at that moment in time he can no longer trade with any of his physical assets that he possesses, such as his home or his possessions.
حتى الفلوس اللي عنده النقود هذه أيضا محجورة.
Even the cash that he owns, he is also prevented from transacting with that cash. So how can he purchase? He can't purchase with the physical asset, he has to purchase with a debt. Meaning? Why? Because all of that cash, all the physical asset that he has, it is now is the rights of the debtors that he owes the money to. Basically it gets distributed up.
طيب الآن الثاني من الذين هو الشرع على مصلحة الحجر الذي يشرع عندنا المريض فيما زاد على الثلث.
The example we did was a person who is in debt and is insolvent, right? The second one, that's which the rights of the debtors are taken into account. That's where the interdict exists. In the second scenario is where the person who is ill and he is interdicted for the right of his inheritors.
فإذا كان الإنسان عنده مرض وهذا المرض يشترط أن يكون مخوف أي يخاف عليه الموت بسببه.
So which kind of illness is it when you are prevented from transacting? It is the illness where you are fearful that you are going to pass away from that illness.
أو هذا المرض غير مخوف لكنه مات بسببه.
Or the illness that you have, the illness in itself is not something that you generally fear you're going to die from, but you happen to die from that illness, nevertheless.
فنقول إذا كان عنده مرض من هذا الشيء ومات به نقول ما حكمه وأثناء المرض قال نصف مالي للفقراء والمساكين مثلا نقول الثلث يعطى الفقراء والمساكين أما ما باقي زاد على ذلك فهذا حق الورثة.
The example is, for example, someone has an illness, and that illness is an illness that they die from. But during the illness, what they did was they said they gave a sadaqah, for example, half of my wealth is to be given to the poor and the needy. Right? So what we say is that because you died from that illness, only a third of what you intended from your estate that was given as sadaqah is given off as sadaqah, and the remainder is restricted, is not given to the poor and the needy, because you are only allowed to transact in the third if you are in the illness that you either die from or that you fear to die from in the scenario.
أما لو فعندنا هذا المريض المخوف الذي يؤدي إلى الموت، لو كان تصدق مثلا بأي أنواع التبرعات، نقول في أثناء مرضه نقول الثلث وما دونه ينفذ يعطى لغير الورثة. أما لو كان تبرع للورثة فلا ينفذ شيء من ذلك إلا إذا رضي الورثة كلهم.
The next scenario is that the person is in an illness, and the illness itself, he fears that he will die from this illness. It's an illness that he fears to die from. He is permitted, again, he can give his money in gifts to up to a third. That which is beyond the third, if it is given to any of the inheritors, then that is not automatically executed. The inheritors that will have to give permission for them to allow the remainder of the gift to be transacted, that which is above a third. Or if it is to the inheritors as well, the other inheritors have to give permission, say that it's okay, you can give to the other inheritors if it's above a third, or if it's to the inheritors themselves.
فالمريض هذا محجور في جميع التبرعات. ما هي التبرعات؟ صدقة، هبة، وصية، عتق، وقف.
So when what kind of transactions are we referring to that he is prevented from doing? Transactions which is considered what is known in Arabic as a tabarru', which is a gifting type of action when there is no, such as a sadaqah, you gift someone something. No.
هبة، وصية، عتق، وقف.
Or you free a slave, or you give a bequest, or you make a waqf of something. These are all forms of gifting. In different, with utilizing different avenues. All of these things, they are prevented from up until the third, and beyond the third you have to have permission from the inheritors, or if it's to an inheritor you have to have permission.
فلو كان الإنسان عنده هذا المرض مثلا مخوف يؤدي إلى الموت مثلا، ونقول وهذا المرض الذي فعله ده مثلا نقول ايش نقول عندنا المرض الذي حصل له مثلا اعطى لبعض الاولاد ولم يعطي لبعضهم، مثلا سواء كان الثلث او اكثر من الثلث او اقل من الثلث، او اعطى للذكور ولم يعطي اناث مثلا، سواء كان الثلث او اكثر او اقل، نقول لا ينفذ شيء منه الا باجازه بقيه الورثه.
So the example Said gives now is, for example, someone has an illness in which they are fearful that they will die from this illness. So as we said, gifting in the end of the sorts, they are prevented above the third. But in the scenario Said mentions that where this person wants to gift it to some of the inheritors themselves. He wants to give to the girls alone, or to the boys alone, or to some of the inheritors to the exclusion of others. In this scenario, that he has to have the permission of the other inheritors if he wants to gift an extra amount to the inheritors themselves, right? It's none of it is automatically given as gift. He has to have the permission of the others in the scenario if he has an illness which he fears from.
لماذا حجر عليه؟
Why is an interdict placed automatically against him?
لأنه المريض غالبا قد يكون قبل أيام مرض يكون ما ينفق كثير، فقد يكون عنده المرض يخاف من الموت فينفق بكل ماله فيضيع حق الورثة، فجعل الشريعة الثلث فقط ينفذ لغير الورثة، أما الورثة فلا ينفذ شيء إلا بإجازة البقية.
So as we said that why did is he interdicted automatically in the scenario? It doesn't require the qadi. Is because what happens at the time of death or close to death, a person wants to give all their wealth away, and then they neglect the inheritors in terms of what they're going to receive. So Allah Ta'ala has said that no, you can give up to a third to other than an inheritor, and that's automatically is executed. But if you the moment you're giving to an inheritor, as we said, then you have to require the permission of the other inheritors.
كذلك حتى في غير الورثة لو قال كل مالي لوجه الله مثلا، فنقول ينفذ إذا كان هذا كلمة في مرض مخوف، نقول الثلث ينفذ، ما زاد على الثلث لا ينفذ إلا إذا جاءت الورثة.
Another example Said gave is when someone is on their deathbed, for example, or in an illness that they fear dying from, and he says that I give in charity all of my wealth, 100% of my wealth. So we say to other than the inheritors, right? So it's to a stranger, for example. We say that up to a third automatically is executed. That which is above the third requires the permission of the inheritors.
كذلك عندنا من الذي يحجر لمصلحة غيره العبد الذي لم يأذن له سيده في التجارة. العبد عندنا الذي لا يحجر عليه، الذي يحجر لمصلحة غيره العبد يحجر عليه لمصلحة السيد. فإذا كان السيد لم يأذن له في التجارة لا يحق للعبد أن يبيع ويشتري.
So the next category of person who is interdicted for the right of someone else is a slave. A slave, who the master has not given him permission to trade on his behalf, he is not allowed to trade on his behalf. Why? Because of the right of the master.
طيب فعندنا ماذا؟ العبد عندنا لا يحق له جميع التصرفات المالية، وعندنا إذا السيد أذن له في التجارة تمام، ما أذن له في التجارة ما يحصل منه لا بيع ولا شراء.
Example is a slave. The base ruling for a slave is that he cannot trade in any trade at all, right? Without the permission of the master. If the master gives him permission and said, okay, you can trade, buy and sell, then he can trade and buy and sell. But if he has no permission, he is automatically all of his trade and his selling is invalid. Right? Automatically he is considered someone who is interdicted.
ثم قال بعد ذلك تصرف الصبي في المثل عندكم تصرف الصبي والمجنون والسفيه غير صحيح. شرحنا ذلك من قبل أن تصرف الصبي في البيع والشراء أو المجنون في البيع والشراء أو السفيه في البيع والشراء مثلا غير صحيح.
As we mentioned that the trade of a minor, a child, and a person who has lost his intellect, such someone that has lost his intellect, the trade is completely invalid as we've discussed previously.
طيب من يتصرف في مال الصبي؟ ذكرنا الدرس الماضي أن يتصرف مال الصبي هو الولي اللي هو عندنا الأب ثم الجد ثم الوصي ثم الحاكم أو الأمين.
Who trades on the behalf of the child with regards to his wealth? As we mentioned last week, it's the father, it's the wali of the child, who is the father here, and then in this order is then the grandfather, and then in the absence it would be what is known as the wasi, someone who has been given the right of permission by the permission of the father, and then if the absence of that, then it is the judge who then transacts on behalf of the child.
فالصبي كما قلنا ما يصح تصرفاته إلا في مسائل يصح منه تصرفات.
The base ruling with regards to a child, a minor, is that his trade and his transactions are invalid, except for a few exceptions.
مثلا عندنا إذنه في دخول الدار. لو واحد جيت أنا دقيت الباب دار الإنسان مثلا فتح لي صبي ثم قال للصبي ادخل في الغرفة دي، أذن لي في دخول الدار. أصلا ما الإنسان لا يحق له دخول الدار، لكن الصبي أذن لي، فهل آخذ بكلامي؟ نقول نعم خذ بكلامي وادخل حيثما أمرك الصبي ذلك.
And one of the exceptions where the transactions of a child is permitted is the permittance to enter a home. For example, someone knocks on the door of a house and a child answers the door, and then the child gives you permission to enter the door. The base ruling is that you don't have permission to enter the house because it's the child that's giving a response. But the Sharia says that no, the statement of the child that you can enter the home here is considered permission for you to enter the house, and it's permitted in that scenario. Even though the general ruling is that these transactions are not permitted, but in that scenario it is permitted. Permission to enter.
يعني إيصال هدية إذا لم يجرب عليه الكذب. مثلا قلت واحد قال لي خذ هذا هدية من أبي، فهل يجوز لي أخذ هدية بقول صبي؟ هو ما قال هدية مني، قال هدية من أبي لك. قال يصح ذلك إذا لم يجرب عليه الكذب.
Another scenario where it is permitted for the transaction of a child, for example, it is the giving of a gift. For example, you give a child a gift to give to an adult. The child takes the gift to the adult and says, "This is a gift from my father to you, or my mother to you." This is permitted for the child to give the gift, and it's permitted for the person to receive the gift from the child. And you can accept this statement that this is a gift from the father, with the condition that the child is not known to lie.
نعم. كذلك عندنا ماذا؟ توكيله في تفرقة الزكاة. نأخذ يا ولد هذا أعطي الزكاة لفلان، إذا عين له المدفوع له، خذ الزكاة هذه أعطيها لفلان، خذ الزكاة هذه أعطيها لفلان، خذ الزكاة هذه أعطيها لفلان. هنا يسمى تفرقة الزكاة، إذا عين مدفوع عليه فإنه أيضا يصح منه من الصبي.
You can have a child. Another third example of what's permitted is that a child is permitted to distribute zakah on your behalf, provided that you specify specifically what and who you're giving it to. Take this money to that person over there. Take this money to person so and such a person. As you must specify who the person is, so that and then it will be permitted for the child to take that zakah and give it to that person. That is another scenario where it is permitted.
ثم قال ماذا؟ وحكم تصرف المفلس عندنا، وتصرف المفلس يصح في ذمته دون أعيان ماله. شرحنا ذلك دون أعيان ماله، شرحنا ذلك قبل قليل. إن نقول المفلس هذا ما يمكن يعني يتصرف في أعيان المال، يعني يأخذ شيء من أموال أعيانه ويبيع أو يشتري بها، وهذا لا يصح ذلك. لكن في ذمته يصح، لا إشكال فيه.
So the text says the person who is insolvent, he is not permitted to transact in his physical assets, right? What is known in Arabic as a'yan malihi, but he is permitted to interact or to trade with that which is in a debt form, which is in his seat of responsibility, something that's not a physical asset, right? That's exactly the difference, as we mentioned before, is that physical assets you can't trade in, but you can trade in his seat of responsibility, not in a physical asset.
كذلك عندنا ماذا؟ في ميزان عندنا كذا، عندنا يتكلم في، طب كيف عندنا في ذمتي مثلا عندنا يبيع في الذمة يصح؟ يبيع متاع موصوف في الذمة يصح؟
So what does it mean by transacting in your seat of responsibility in your dhimma? Say, for example, says that
إذا كان يبيع متاعا موصوف في الذمة.
So for example, I sell you an item of a description in my mind. So I describe something to you, not a physical asset, but I describe an item to you. This is me trading with you, something that is described, something that exists in my seat of responsibility. So I'm due to sell you an item that I've described. So that's in my seat of responsibility. It doesn't exist physically yet, right? Or it exists physically but not here. So that's what's trading in seat of responsibility.
أو اشترى بثمن في ذمته، أي اشترى بالدين يصح أيضا كما ذكرنا قبل قليل.
Or you, for example, you purchase an item with cash that doesn't exist physically yet in front of you, but in your dhimma, meaning in your physical seat of responsibility, meaning I purchase an item from you with a 10 rand that I owe you. So the 10 rand isn't physically in front of you, it's something that is in my receipt of responsibility, which exists as a debt upon me. It's permitted for me to trade like that, but not in a physical 10 rand.
كذلك عندنا يصح لو الحاكم أعطاه شيء من المال مثلا ليشتري نفقته ونفقة عياله، يصح ذلك ولا إشكال.
So the examples again we're talking about when they are permitted to trade, the insolvent person. We said that in his seat of responsibility, his seat of responsibility as a debt, or when the judge gives him a portion of wealth to purchase his nafaqah, his food and provisions that he requires for him and his family.
كذلك قال وتصرف المريض أي مرضا مخوفا فيما زاد على الثلث موقوف على إجازة الورثة من بعده كما شرحنا ذلك.
And the text again says that the transactions of the person who has an illness which is feared of death, right? That which is above a third, anything above a third is dependent, is withheld until the permission of the inheritors.
لكن هنا في مسألة مهمة.
It's an important issue that we need to discuss.
ما هي المسألة المهمة؟ لو كان طيب لو كان عندنا الأب قال أنا كل مالي للفقراء والمساكين، فالورثة لا يحق لهم يقولون رضينا أو لا رضي أو راضين أو غير راضين إلا بعد وفاة المورث. قبل وفاته لا عبرة بقولهم رضينا أو ما رضينا. بعد وفاة المريض هذا هنا يحق للورثة أن يقولوا رضينا أو لم نرضى.
When is the time, for example, when a father, for example, says that he wants to give all his wealth away, right? We said that that which is above a third requires the permission of the inheritors. But when is the time when they make that statement, when they grant the permission or not? It is after the death of the father. And they can say, okay, we are happy with it or not happy. Prior to the death, they don't have the right to say, we grant permission, we don't grant permission.
نعم. كذلك ماذا عندنا؟ قال وتصرف العبد يكون في ذمته يتبع به بعد عتقه. هنا وحين عبد السيد لم يأذن له في التجارة. طيب العبد هذا أخذ بعض الأشياء مثلا من سيده وراح باعها، والشخص اشترى منه ومشى. طيب هذا الشيء الآن ماذا كيف نفعل به؟ الشيء اللي أخذه من السيد، أو شيء اشتراها من الناس مثلا وجاء أخذها العبد وأتلفها ثم تبين العبد غير مأذون في التجارة، ماذا نفعل؟
So for example, the example Said gives, for example, is a slave who trades without the permission of his master, and he takes it and someone purchases the item, or for example, he does not have the permission to purchase to sell something of his master without the permission, or he purchases something from someone, but then afterwards it comes to our information that he didn't have permission, but he ends up destroying the item that he purchased from without permission. What do we do in this scenario? He didn't have permission to trade, but the item is now damaged or destroyed. What do we do with the slave?
نقول ماذا؟ يقول يكون إذا تصرف العبد بغير إذن سيده وأخذ الشيء منه وأتلفه، قال يتبع به بعد عتقه، لأنه الآن ما يملك شيء، العبد وما ملك لسيده فهو لا يملك شيء الآن. طيب ماذا نفعل؟ نقول ننتظر حتى يعتق السيد ثم يصبح ذو يسار ناخذ منه ما أتلفه في أيام ما كان عبد.
So for example, if he was permitted by his master to trade even and he damages the item or destroys the item, then what happens is that you can't take into account now for what he damaged, because he is only taken into account with regards to that which he damaged after he is freed. So what happens is that with the amount that is due on him, right, for what he damaged, right, you first have to wait until he is freed, and then after he is freed you have to wait until he has money, and after he has money now you can say, okay, give me my money for what you broke, what you damaged.
فالعبد في أمور المال لا بد من إذن السيد، أما في أمور العبادات والطلاق فيصح منه ولو بلا إذن سيده، أما في الولايات فلا يصح منه وإن كان بإذن سيده.
So for example, in three scenarios, in terms of wealth, he cannot trade without the permission of his master. In terms of ibadat, he does not require the permission of the master to perform any ibadat, right? In terms of wilayat, in terms of marriage, etc., then he has no rights to transact in any form of wilayas, wali, for nikah, for example, even if his master permits him.
انتهينا من الدرس. من عنده سؤال يتفضل.
We've ended the class now, and if there are any questions, you can ask a question.
About Assalamu alaikum. Assalamu alaikum, Ya Sheikh. I just wanted to ask, relating to the person that's terminally ill, and that he can only give 1/3 of his estate, all right? If the person is not sick or have a terminal illness, has he got rights to give up the inheritance away before the time? And can it be done, for example, you give because you'd want to deprive somebody else after you
want
die.
to deprive.
Not want to, but in essence, that is what you are doing. You understand me? So I'm giving all my wealth to my inheritors, with the sense that the others that can inherit won't have as access to it.
Is your intent to deprive him or not?
Indirectly, probably, but not overtly, man. Do you understand what I mean?
Yeah, but,
Is the understanding I'm doing this because I have less to give to those that are not directly linked to me.
okay.
Understand? So the first thing is, can only a person that's terminally ill or sick that might lead to death, can he is he the only one that can give away, or can a person that's healthy also give the wealth away to others before they pass away? And can it be done with the intention of not giving somebody else the haq after they passed away?
No. So the question is, for those who didn't hear, the first thing is that can someone who is in complete health give away all of their wealth or a large portion of their wealth without the permission of the inheritors? That's question one. Question two is that am I permitted to do this with the intent of depriving those who generally inherit? For example, giving the girls instead of the boys, by example. سيد السؤال يعني له جزءان. الجزء الأول من السؤال أنه هل يجوز لشخص غير مريض أن يتصدق بجميع ماله؟ هذا السؤال الأول. والجزء الثاني الشخص الذي يتصدق بجميع ماله يعني ولكن بقصد حرمان بعض الورثة، يعني يتصدق على الإناث دون الرجال بقصد حرمان الرجال أو الذكور. هل يصح أن يتصدق في هذا السؤال؟
أولا التصدق بجميع المال إن كان لا يترتب عليه ضياع حقوق الناس فهذا جائز ولا إشكال فيه. قد فعل سيدنا أبو بكر الصديق، تصدق بكل ماله بهذه مع رسول الله. لكن إذا كان سيؤدي إلى ضياع الحقوق أو سيؤدي إلى تكسير في النفقة في حق الزوجة والأولاد وهم غير راضين بهذا مثلا، فهنا نقول حرام ولا يجوز ذلك.
So, for example, it is permissible for someone who is of the health to give sadaqah of the entire estate, provided that you are not going to be depriving those who are due for you to provide for. Such as Abu Bakr radiallahu ta'ala anhu, who gave sadaqah with all of his wealth, but it was understood to be that those who are his dependents was happy to have sabr in the poverty that would ensue. But if those who are dependent upon you are not happy to ensue with the poverty as a result of your distribution of your entire estate, it would not be permissible for you to give your entire estate if it's going to result in their deprivation. Right? So otherwise the ruling is yes, provided you're not going to deprive those who are due for your nafaqah.
أما التصدق لبعض الأولاد دون بعضهم من غير قصد حرمان فهنا مكروه. إذا كان في حال هذا مكروه
بدون قصد.
إذا كان بدون قصد سأتكلم عن القصد.
So for example, if you give all of your wealth whilst to a specific group of your inheritors, but it's not with the intent of depriving the others, and it's makruh. Without the intent.
إذا عندنا مثل كذلك عندنا سواء تصدق للذكور دون إناث أو للإناث دون الذكور ولم يقصد الحرمان أعطى بعض، هذا عندنا مكروه. نعم، لا ينبغي فعل ذلك إلا إذا كان هذا الفعل مثلا يعطي مثلا لبعض الأولاد دون بعضهم مثلا لتميز أو لفقر عندهم أشد من الآخر، فهنا لا بأس بذلك.
Unless there's a real reason unless there's a reason for you to give it to them. For example, someone is poor. You have a child who is very impoverished and versus a child who's not impoverished. It's not makruh for you to give that child more because there's a need for him to receive.
نعم. أما إذا كان بقصد الحرمان فهنا محل خلاف. في من قال أنه حرام وفي من قال أنه مكروه.
And the scenario where you intend to deprive the inheritors, there's a khilaf amongst our Shafi'i ulama. The one group of Shafi'i ulama say that it is haram for you to do that. The other group says it's actually still makruh for you to do that. In other words, that you can intend to deprive.
وهذا مما لا ينبغي.
but it's necessary for you not to do, not something that you should be doing. With the intent.
لا ينبغي للإنسان أن يكسب بإعطاء البعض دون البعض بقصد بذلك الحرمان. لا ينبغي ذلك أبدا.
It's not befitting of a Muslim to intend to deprive one portion of the letters at the expense of others.
وهذا قد يسبب العقوق.
This could lead to the breaking of family ties.
بل يحصل كثير من الكراهية للأب بسبب أنه لم يعطي شيئا بل أعطى لأخيه أو أخته مثلا.
So this can result in a lot of family issues for the father when you give the one child or not the other child.
نعم. يقول عندنا ماذا؟ أيوة كما قال هنا الشيخ في الحجر قال وإن قصد في الوقف وإن قصد حرمان ولدته صح لكن عليه الإثم في باب الوقف.
So for example, say it gives an example of waqf. For example, I make waqf of a portion of my wealth on some of my children with the intention of depriving others. Only, for example, waqf of my home, only on my daughters, for example. And then one of the Imams, the Shafi'i Madhab, Ibn Hajar says that the transaction is valid, meaning they can validly take possession or utilization of that sadaqah, but it's haram for me to work for cause of my intent. It's haram, but it's still valid.
حتى الهدية نقول هدية يصح لكنه على ما ذكر الشيخ يكون حرام هذا القصد.
Similarly, if I give an item to people with the intent of depriving others, if that's my intent, it's haram, the intent, but they validly own the item I gave them. So it's a valid transaction.
كما حصل مرة أن واحد عنده ابن وبنت.
There was an example where someone had a son and a daughter.
فأعطى كل ما يملك للذكر وحرم البنت.
So he gave everything he owned to the son and nothing to the daughter.
فكانت زوجة البنت هذه كل مرة يعاتبها شوفي أبوك حرمنا من الإرث حرمك من الإرث هذا أبوك كذا هذا أبوك كذا فسببت كراهية من البنت لأبيها كرها شديدا.
So for example, what happened was that obviously every time the husband of this daughter would remind her, you see your father, he deprived us of inheritance, we didn't get our money, he deprived the inheritance, etc. Reminding all the time of how the father deprived them of her money that was due to them, and it made the daughter dislike the father terribly.
حتى أن البنت دعت على أبيها قال اللهم أنه حرمني حقي فحرمه من الجنة.
So to the point that she eventually made dua against the father, where she said that, Ya Allah, he has deprived me of my inheritance, Ya Allah, deprive him of Jannah.
وهذا طبعا البنت ما كان ينبغي لها مثل ذلك.
Obviously, it's not befitting for the daughter to make a dua such as this.
لا ينبغي لا للذكر ولا للأنثى أن يفعلوا مع الأب والأم مثل هذا أبدا أبدا أبدا.
It's never befitting of a child to make a dua, whether it's a male or a female like this, against the father in any scenario, ever.
بل يقول رب ارحمهما كما ربياني صغيرا.
But rather make dua that Allah Ta'ala have mercy on them like they had mercy on us when they raised us up from small.
لكن أنا أحكي لكم هذه القصة لأجل ينتبه الأب أو الأم إعطاء بعض الورثة وترك البعض.
I mentioned this story for you to understand the severity of what happens when you give one portion and at the expense of another.
من عنده سؤال؟
Assalamu alaikum.
عليكم السلام.
Just a question for the person who's terminally ill. Is that person allowed to divorce their spouse while they are in that state?
Just هل يصح الطلاق الذي كان في مرض مخوف؟ هل يصح طلاقه؟
نعم الطلاق يصح. الطلاق يصح لا إشكال.
The divorce is valid.
بشرط أن يكون طلق وهو واعي مدرك ماذا يقول ليس عنده مرض صار يبذر بالكلام فنطق بلفظ الطلاق وهو لا يدري ماذا يقول. هنا لا يقع الطلاق أبدا.
Provided that obviously is of his senses. If the person's of the senses and they're confused, they don't know what they're saying, they don't know what the words mean, etc., then obviously that would not be valid because it's not of his senses that the talaq would not be valid and it's outright, even in a healthy person. But as long as he understands what he's saying and what the words mean, and then that talaq would be valid. Yes.
But in the sense of it,
أنا عندي سؤال أو خلاص انتهينا.
نعم، وإن كان يقصد يعني بهذا الطلاق حرمان الزوجة سيدي.
الطلاق واقع في كل حال.
So even if he intends to deprive the wife of the inheritance, then the talaq is valid, provided he's of the senses and he knows what he's saying.
لكن ممكن يكون السؤال لو طلقها طلاق رجعي أو طلاق باين مثلا، هل ترث منه أو لا ترث منه؟
So the difference here would obviously be if it depends on the type of divorce. So you get two kinds of divorces: divorce which you obviously like a permanent divorce, where you divorce and you're no longer married, and she's just the way the iddah, and you have to remarry, or the divorce which is a raj'i, where you a revocable divorce, where you can remarry. So the question should rather be that if a divorce is a revocable divorce, does she inherit or not? So she's divorced, but it's a revocable divorce.
نقول أولا إذا طلق طلاق باين وهو الطلاق الثلاثة أو طلاق الخلع فإنها لا ترث منه.
For example, if the divorce occurs as a result of what is known as a buy-in divorce, which is in English we translate as an irrevocable divorce, either the third divorce or three divorces in one, or what is known as a khul', where she pays for the divorce. Then in these scenarios, once that occurs, she is now considered an irrevocable divorce, right? And she doesn't inherit from him.
أما لو طلقها طلاقا رجعيا طلقة أولى أو طلقة ثانية فإنها ترث منه.
If it's a revocable divorce, first or second divorce, then after that divorce is occurred, she still inherits from him.
هكذا صحيح، هكذا أحفظه. إذا كان طلاق رجعي فإنها ترث منه، صحيح.
ما لم تنقضي عندي في الرجعية. يعني هي في حكم زوجة.
نعم، بس في مسائل لا، بس باب الاحتياط بس. نعم ترث. نعم.
ما لم تنقضي العدة. ما لم تنقضي العدة.
نعم إذا كان العدة أصلا خلاص ما هي رجعية.
As long as the iddah is still in the iddah.
والله أعلم. أي حكاية ما يبقى هنا بالدين. علمنا التأويل هنا سواء السبيل مع صلاح شام ظاهر باطن في الدين. أول شيء قبل ما أنتهي في سؤال من النساء.
سؤال من الرجال ثاني، سؤال من النساء.
لا من النساء. الرجال سألوا أسئلة.
أظن هذا من النساء. If one gives of his wealth during his lifetime to one living inheritors greater than a third while he is not terminally ill on his deathbed, does there need to be witnesses to confirm that this portion of the wealth was gifted? And if there is none, but the receiver of the gift claimed to have been given this portion without the knowledge of the other inheritors, what should be done? شخص غير مريض تصدق بأكثر من الثلث، هل يجب أن يكون هناك شهود حتى يثبت أنه تصدق بهذا المال على بعض الورثة؟ وادعى أحد الورثة أن يعني الأب تصدق عليه هذا المال، يعني وحصل الإشكال ومن المصدق في هذه الحال؟ هل يجب علينا أن نرجع إلى الشهود أم يعني ما هو الحل؟
أول شيء هو الأب حي ولا ميت؟
أظنه لا لم يثبت.
طيب على كل حال نقول إذا كان أول شيء إذا أنت صدق به قبل في حال الصحة ليس مرض فهو نافذ.
نعم.
نقول يرسل لا إشكال. اشرح هذا وين.
If the father was in a state of health and he gave that sadaqah, we're saying that the sadaqah is valid firstly, if this actually occurred. Right? Now the opposite question
فإن كان نعم فإن كان هذا الولد مثلا نقول إذا مات الأب فادعى الولد بعد أحد الأولاد أن أبوه تصدق به في حال حياته.
No. So one of the sons now claims that he's now making a claim that the father gave him this thing as sadaqah during his lifetime whilst he was healthy.
إن كان الأب حي طبعا نرجع إلى الأب، لكن أبوه مشكلة أنه ميت. نقول لهذا المدعي هذا هل لك بينة؟ شاهدين يعني؟ شاهدان أو شاهد امرأتان أو شاهد يمين مثلا.
Now, so the son or the inheritor who claims that they was given a gift from the father whilst they were healthy, if the father is still alive, obviously just go to the father and ask him. If the father's passed away, in the scenario the father's passed away, then now you ask this person, do you have, for example, do you have witnesses, either to male witnesses or to female witnesses and the male witnesses, and there's different kinds of proofs you can use to establish wealth.
طيب قال ما عندي بينة.
So he says there's
نرجع إلى الورقة البقية. هل تعلمون أن أبوه أهدى له شيء أيام الصحة قبل مرض؟ قالوا لا نعلم شيء. طيب احلفوا بالله. إما يحلفوا بالله أن يقول والله أبونا ما أعطانا شيء، أو يحلفوا على عدم يقول والله لا والله لا نعلم أن والدنا أعطى شيء مثلا. خلاص يكون هذا الإرث كله يقسم من جديد على كل وضع.
So for example, so now we have the scenario, there are no witnesses. This is now after the fact. So now we ask the inheritors, the judge will ask the inheritors, do any of the inheritors know that whether there was a sadaqah given by the father to this other brother? If they are certain that they did not give, he did not give, or they're not certain but they know they have to take an oath in saying that Wallahi al-Azim, that our father did not give, or Wallahi al-Azim, we do not know that our father gave us a sadaqah. And if the judge then accepts that, then then the inheritance will then be distributed without that portion that was given as a gift. Since obviously with this conflict.
فإذا كانوا لا نحلف.
So if the other children say we will not take an oath, this is a serious thing to take an oath.
إذا نرجع الحلف إلى المدعي هو قال هذا أبوي أهدى لي، فإن حلف يسمى يمين مردودة، فإذا يملك كل ما أعطاه في حال.
So in this scenario, right, there was the claim from the person who said that the father gave sadaqah, and then now the other inheritors have to make an oath that the father didn't give us sadaqah. So they refuse to take an oath. So this is what is known as an oath which is returned to the claimant, right? So when the oath is returned to the claimant, right, he now takes an oath. Says that Wallahi al-Azim, my father gave me sadaqah, and then that is the equivalent of witnesses. In the scenario when it returns back to him, and he then receives what his father gave him as a sadaqah. What his claim is gets established, and that is now says that okay, then it's validly given to him as sadaqah. So it says here that the yamin al-marduda, that the oath that there is, when they refuse to take an oath and then they allowed him to take an oath now, then this is the same thing as if the person he himself has established that this I truly gave this as sadaqah, what is known as iqrar.
نعم. طيب عندنا شو نقول نعم هذا هو في مسألة.
هل يلزم أن يكون يعني المدعي عدل أو صادق؟
لا الشاهدان لا بد يكونوا.
No, only the witnesses have to be true. So he could be an untruthful person, but obviously he's taking an oath.
نعم. هنا مسألة لو جاء بورقة نسيتها، لو جاء وقال شوف هذا أبي كتب ورقة ووقع عليها،
So another example would be that you see, here's my father, you see, here's the piece of paper, he wrote it and he signed the piece of paper.
فإن كان هذه ورقة موثقة، الأصل عندنا عند الشافعية لا يقبل هذه الأوراق والتواقيع عليها، لا يقبلونها الأصل.
So in the Shafi'i madhab, the piece of paper that has a signature on it, the signature doesn't carry a weight. Yeah. That's the
لأن يكثر فيها الأكاذيب والتزويرات.
Because it's possible for there to be people that have altered the stuff, etc.
لكن إذا كانت هذه الورقة في المحكمة الشرعية أو محكمة قبلوا هذه الورقة، عرفوا أن مصدرها موثق وأن فيها مثلا توقيع مؤكد وهكذا، وعلموا أكيد أن هذا هو وقع، إذا نثبت هذه الورقة على قول من يقول بجواز إثبات التواقيع.
No. So some of the madhab do permit it. So what happens is that if you come to a court system and that court system permits and considers the signature a valid proof of him actually giving us the sadaqah, etc., and establishing the validity of the document, and as provided that the court says that this is a valid document and his signature is a valid signature and there are no issues there, then you can utilize that based on the position of those ulama who do permit it as a means to establish the validity of that sadaqah that was given to the child over there.
والله أعلم. فاتح الله فقهكم بدين يعلمنا التوحيد ما صح عشان ظاهر الباطن في الدين آخر بسر الفاتحة وإلى حضرة النبي. اللهم صل. الله الحمد لله رب العالمين. حياكم الله يبارك فيك.
On my mic, okay. The doctor.